Hello, 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 everyone, and welcome to Uncivil Law. I'm your host, and with me is Tactical Bra. Say hello, Tactical Bra.
Hello, everyone.
Hello. And we have a wonderful selection of stories for you today. We are going to start with executive privilege, per Tactical's request, because I love to accommodate her. And we are going to discuss the concepts of this, and we're going to read the best case on point, the United States Supreme Court case of U.S. v. Nixon, dealing with the last time this came up in a major way during the Nixon impeachment inquiry. So we're going to read the case, and we're going to read what it has to teach us about executive impeachment, or executive privilege, apologize. Long story short, executive privilege is something the executive fundamentally invented from thin air. And what happens is Congress says, we want stuff, and the executive says no. And then Congress says, please, and the executive says no. And then sometimes when they go to court, what the courts say is, well, everything Congress does is inherently political. It's impossible for it not to be political. It's inherently political. And so whatever dispute you guys are having must be political. It's not legal. And courts don't do politics. They do legal. At least hypothetically, that's what they're supposed to do. So this is considered a political question. The executive and legislative branches are fighting each other. It's over the politics of it. And so the resolution is supposed to be political, not legal. Of course, all exceptions meet the rule, and this is one such example with U.S. v. Nixon where this came to a head. So we're going to read through this, see how it teaches us, and go from there.
I think one of the other things that the judiciary doesn't like is that Congress and the executive are co-equal, and then the judiciary is being asked to be the tiebreaker, and they really don't like choosing a winning side for two co-equal branches of government.
Yeah, especially because Congress is unavoidably political. And I guess hypothetically, you could say the executive is at least partially separated from political, but it's considered a political branch. So you got two branches of government that are political and one that's legal. And it's like, do you want the legal branch picking a political winner? That doesn't go over very well. So, yeah, they try to avoid that when they can. Um, so that's, yeah, Bush v. Gore, of course, being a more infamous example where they got involved with what was ostensibly a legal question, but related to an obviously highly political issue. And they're still being criticized for that to this day, not without some justification, in my view, because not to my knowledge, as I remember the case, not a single justice analyzed whether it was a political question at all. None of them even bothered asking the question. But that's a thing that happened. So we're going to read U.S. v. Nixon and see what it has to teach us about the issue of whether or not President Nixon needs to turn over tapes of recordings that were recorded in the White House to Congress, tapes which may be damaging to him. So we're going to read what the Supreme Court had to say about this. The threshold question presented is whether the May 20th, 1974 order of the District Court was an appealable order, and whether this case was properly in the Court of Appeals when the petition for certiorari was filed in this court. So long story short, Congress went to District Court to get them to do something, and the District Court did something, and now they're wondering, is this ripe for appeal? The Court of Appeal jurisdiction under 28 U.S.C. 1291 encompasses only final decisions of the district courts. Since this appeal is timely filed and all other procedural requirements were met, this petition is properly before the court for consideration if the district court was final. And so this is called certiorari before judgment. In this context, before judgment means before the judgment of the Court of Appeals, not before the judgment of the district court. And this happened relatively recently in the census case, where the people who are challenging that went straight from district court right to the U.S. Supreme Court because of the importance of the case. So it's not a usual process, but it is allowed for in the rules. The finality requirement of 28 U.S.C. 1291 embodies a strong congressional policy against piecemeal reviews and against obstructing or impeding an ongoing judicial proceeding by interlocutory appeals. This requirement ordinarily promotes judicial efficiency and hastens the ultimate termination of litigation. In applying this principle to an order denying a motion to quash and requiring production of the order pursuant to a subpoena docus tedum, it has been repeatedly held that order is not final and hence not appealable. So they're saying that certain things are not appealable um, even though you might think they should be because, just because of policy reasons. So, they're saying that this is an example of something that might not be appealable. This court has consistently held the need for expedition in the administration of criminal law justifies putting one who seeks to resist the production of desired information to a choice between compliance with trial court order to produce prior to any review of that order and resistance to the order with the concomitant possibility of adjudication of contempt. The requirement of submitting to contempt, however, is not without exception. In some instances, the purposes of underlying the finality rule requires a different result. So the Supreme Court is saying most of the time, if you disagree with this, you just have to not submit it. You have to go under contempt, and you have to hope it's going to all work out in the end. But they're saying, well, we might want an exception to that rule under certain circumstances, like the one before us, perhaps. For example, in Perlman versus United States, a subpoena that had been directed to a third party requesting certain exhibits, the appellant, who owned the exhibits, sought to raise a claim of privilege. The court held ordering compelled production was appealable because it is unlikely the third party would risk a contempt citation in order to allow immediate review of the appellant's claim of privilege. That case fell within a limited class of cases where denial of immediate review would render impossible any review whatsoever of the individual claims. Here, too, the traditional contempt avenue to immediate appeal is particularly inappropriate due to the unique setting in which the question arises. To require the President of the United States to place himself in a posture of disobeying an order of a court merely to trigger the procedural mechanism for review of the ruling would be unseemly and would present an unnecessary occasion for constitutional confrontation between two branches of government. Similarly, a federal judge should not be placed in the posture of issuing a citation to the president simply to invoke a review. The issue of whether a president can be cited for contempt could itself endanger protracted litigation and would further delay both review of the merits on his claim of privilege and the ultimate termination of the underlying criminal action for which the evidence is ordered. The appeal from this order was therefore properly in the Court of Appeals, and the case is now properly before this court. So they're saying normally you would have to just suffer the pain of going under contempt, but we're not going to do that because if we did that here, that would be dumb. So, always a good standard, I suppose. Fair enough. Judiciability. We have jurisdiction. Judiciability is, can we render a decision? We have jurisdiction, but do we have actual power to do anything? So that's judiciability. Let's see what the court says. In the district court, the president's counsel argued the court lacked jurisdiction to issue the subpoena because the matter was an intra-branch dispute between a subordinate and superior officer of the executive branch and thus not responsible to judicial resolution. That argument has been renewed in this court with emphasis on the contention the dispute does not present a case or controversy which can be adjudicated in the courts. The President's Counsel argues federal courts should not intrude into areas committed to other branches of government. That would be your political question doctrine right there. If this is a political issue, the courts should stay far, far away. He views the present dispute as essentially a jurisdictional dispute within the executive branch, which he analogizes to a dispute between two congressional committees. Since the executive branch has exclusive authority and absolute discretion to decide whether to prosecute a case, it is contended that the president's decision is final in determining what evidence is to be used in a given criminal case. Reasonable argument goes to unitary executive theory. The president has all the power. Although his counsel concedes the president has delegated certain specific powers to the special prosecutor, he has not waived nor delegated the special prosecutor the president's duty to claim privilege as to all other materials which fall within the president's inherent authority to refuse to disclose to any executive officer. So this special prosecutor is a person within the executive authority, therefore reports to the president, and therefore if you buy the unitary executive theory, the president can order him to do anything. Yes, tactical.
So, just so I understand, one of the arguments is Nixon saying, since I have authority over the special prosecutor, I can determine what evidence the prosecutor can ask for and get in order to investigate myself?
Yeah, exactly correct. He's arguing that because the special prosecutor reports to the attorney general, who reports to him, that the special prosecutor's powers ultimately flow from the presidency, and therefore the president can direct the special prosecutor what evidence to ask for, what evidence to present, and presumably what kind of cases to try, were he so inclined. And the fact that the person that the special prosecutor is investigating is the president is completely irrelevant because the president has all the power. That's basically the argument. Yes.
Oh, I'm not, I don't quite like the implications of that because it essentially puts the president above the law.
Well, and that gets to a philosophical view of what does it mean to be above the law. We were having this discussion before when we were talking about the president's power to do certain things. Like if you say the president has the power to veto legislation, I mean that doesn't make him above the law because the Constitution gives him that power. So if you say, well, the president has the executive power, so he through his subordinates has the power to determine what prosecutions to give. Does that put him above the law because the Constitution contemplates him having that power? So it's like it's an unchecked power. It's a conflict of interest. But does that put him above the law or not is a bit of a philosophical question. What does it mean to be above the law, I suppose, is a reasonable question. I mean, only the president can pardon people, for example. So if the president does it, it's legal. If anyone else does it, it's not legal. So if the president directs the U.S. prosecutor not to investigate himself, is that legal? And if so, does that put him above the law? These are philosophical questions that have no clear resolution. So, yeah. Let's see, where were we? The special prosecutor's demand for the item therefore presents, in the view of the President's counsel, a political question under Baker v. Carr. Baker v. Carr is pretty much the ultimate political question doctrine. We don't have time for it today. It deals with a Senate apportionment in Tennessee, but it's the case probably more notable for any other case for where the Supreme Court really got involved with political issues. It's the one that kind of broke the dam. Big case, not well known, but pretty important constitutional history, since it involves a textual demonstrable grant of power under Article 2. The mere assertion of a claim of an intra-branch dispute without more has never operated to defeat federal jurisdiction. Judiciability does not depend on such a surface inquiry. In United States versus ICC, the court observed, courts must look behind names that symbolize the parties to determine whether a judicial case or controversy is presented. Fair enough. We're not going to look at labels. We're not going to look at what you call things. We're going to look at what things are. We're not that dumb. Fair enough. Our starting point is the nature of the proceeding for which evidence is sought, here a pending criminal prosecution. It is a judicial proceeding in a federal court alleging a violation of federal laws and is brought in the name of the United States as sovereign. Under the authority of Article 2, Section 2, Congress has vested in the Attorney General the power to conduct criminal litigation on behalf of the United States government. It has also vested him with the power to appoint subordinate officers to assist him in the discharge of the duties. Acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to the Special Prosecutor with unique authority and tenure. The regulation gives Special Prosecutor explicit powers to contest the invocation of executive privilege in the seeking of evidence deemed relevant to the performance of those duties. So long as the regulation is extant, it has the force of law. The regulations of the Attorney General delegated certain of his discretionary powers to the Board of Immigration Appeals and required the Board to exercise its own discretion on appeal in deportation cases. The Court has held, so long as the Attorney General regulations remain operative, he denied himself the authority to exercise the discretion delegated to the Board, even though his original authority was his, and he could reassert it by amending the regulation. Interesting idea. So the Attorney General has the power to create certain subordinate officers, as one would imagine. And he has the power to create regulations, as one would imagine. Those regulations, once they go into the Code of Federal Regulations, the CFR, are laws. They are subordinate to statutes, but they are still laws. They have the force of law. And that's what they're talking about. So it's like, okay, well, you did have this power, but there's this regulation that says this. It went through a process in the Administrative Procedures Act to become law. It is now law. And until it's changed, which you can do by changing the regulation, but until that happens, it binds you. You have bound yourself. And so you can't just pull that back on a whim. You'd have to change the regulation. I like that reasoning very much. Let's see, where were we? Here, as in Accardi, it is theoretically possible for the Attorney General to amend or revoke the regulation defining the special prosecutor's authority, but he's not done so. So long as the regulation remains in force, the executive branch is bound by it. And indeed, the United States, as a sovereign composed of three branches, is bound to respect and enforce it. Moreover, the delegation of authority to the special prosecutor in this case is not an ordinary delegation by the Attorney General to a subordinate officer. With the authorization of the President, the acting Attorney General provided in the regulation the special prosecutor was not to be removed without the consensus of 8 designated leaders of Congress. So going to the ability of the president to unilaterally remove certain executive people or not. And again, they're saying in this regulation, it says not. And so then you are all bound by that because it's now in the CFR. Okay. The demands of and resistance to the subpoena presents an obvious controversy in an ordinary sense, but that alone is not sufficient to meet the constitutional standard. In the constitutional sense, controversy means more than disagreement and conflict. It means the kind of controversy courts traditionally resolve. Here at issue is the production or non-production of specific evidence deemed by the special prosecutor to be relevant and admissible in a pending criminal case. It is sought by one official of the executive branch within the scope of his explicit authority. It is resisted by the chief executive on the ground of his duty to preserve the confidentiality of communications with the president, which in this case is himself. Whatever the correct answer on the merits, these are issues of a type which are traditionally judiciable. The independent special prosecutor with a certain need for the subpoenaed material in the underlying criminal prosecution is opposed to the president with steadfast assertion of privilege against disclosure of the material. This setting assures that there is a concrete adverness which sharpens the presentation of issues upon which the court so largely depends on the illumination of difficult constitutional questions. Again, citing Baker v. Carr, which again is a pretty foundational case. Moreover, since this matter is one arising in the regular course of a federal criminal prosecution, it's within the traditional scope of Article III power, which is to say, in the scope of the court's power. In light of the uniqueness of the setting in which the conflict arises, the fact that both parties are officers of the executive branch cannot be viewed as a bar to justiciability. Incidentally, whether or not the president is an officer or not is still disputed, although this line would seem to suggest that he is. It would be inconsistent within the applicable law and regulation, unique facts of this case, to conclude other the special prosecutor has standing to bring this action, and judiciable controversy is presented. That makes sense. Tactical, any more questions so far?
No.
Okay. The subpoena ducis tedum, in other words, the subpoena for stuff, is challenged on the ground that special prosecutor failed to satisfy the requirements of the Federal Rules of Criminal Procedure, which governs the issuance of subpoenas ducis tedum in federal criminal proceedings. If we sustain the challenge, there would be no occasion to reach the claim of privilege asserted with respect to the subpoenaed material. Thus, we turn to the requirements of whether the rule has been satisfied. A subpoena may also command a person to whom it is directed to produce books, papers, documents, or other objects. The court on motion may quash or modify the subpoena if compliance would be unreasonable or oppressive. The court may then direct that the books, papers, documents, or objects designated in the subpoena be produced before the court at a time prior to trial or prior to the time when they're offered to evidence, and may, upon production, permit the books, papers, documents, or other objects or portions thereof to be inspected by the parties and their attorneys. A subpoena for documents may be quashed if their production would be unreasonable or oppressive, but not otherwise. Interesting. The leading case in this court's interpretation of the standard is Bowman-Derry. This case recognized certain fundamental characteristics of the subpoena ducis tedum in criminal cases. It was not intended to provide a means of discovery for criminal cases. Its chief innovation was to expedite the trial by providing a time and place before trial of inspection of subpoena material. As both parties agreed, the case decided in the wake of Bowman has generally been followed Judge Weinfeld's formulation, United States versus Isaiah, as the required showing. Under this test, in order to require production prior to trial, the moving party must show the documents are evidentiary and relevant. They're not otherwise procurable reasonably in advance of trial by exercise of due diligence, and the party cannot properly prepare for the trial without the production and inspection in advance, and failure to obtain such inspection may unreasonably delay the trial, and this application is made on good faith and is not a fishing expedition. Against this background, the special prosecutor, in order to carry his burden, must clear 3 hurdles: relevancy, admissibility, and specificity. Our own review of the record necessarily affords a less comprehensive review of the total situation than was available to the trial judge, and we're unwilling to conclude the district court erred in the evaluation of the special prosecutor's showings under the rule. Our conclusion is based on the record before us, much of which is under seal. Of course, the contents of the subpoenaed tapes could not at that stage be fully described by the prosecutor, because he doesn't have them, so he doesn't know what's on them. but there was sufficient likelihood that each of the tapes contains conversations relevant to the offense charged in the indictment. With respect to many of the tapes, the special prosecutor offered the sworn testimony or statements of one or more participants in the conversations as to what was said at the time. As for the remainder of the
Um,
tapes, go ahead.
Can I interrupt for, okay,
You
so
may.
Canadian, I don't know my American history that much.
No problem.
They are talking about an indictment. Did they indict Nixon while he was a sitting president?
That's an outstanding question, and I do not know the answer to that question. Let's look it up.
Because I think one of the issues that has been recently brought up is that DOJ right now they've decided not to pursue indictments against a sitting president and prefers that the president be impeached first, which I can kind of understand. I think going through this, I'm understanding the logic of not indicting a sitting president a little bit more because the president is the source of the power for the DOJ.
Right. So I'm reading Wikipedia's summary here. Let's see. It doesn't. It doesn't look on those indicted. Does he say who was indicted? No, that would be way too easy. Um. So it looks like some people were indicted and the tape was deemed relevant to those indictments, or it looks like there was an ongoing grand jury proceeding. So technically speaking, they hadn't been indicted yet, but there was an ongoing grand jury proceeding. So it was being submitted to the grand jury. So whether or not Nixon was being contemplated for indictment, it doesn't say. But yeah, I'm not sure who was being indicted by the grand jury. Also, grand jury proceedings are secret, so we wouldn't necessarily know. So,
And do you know if he was indicted after he left office?
well, Ford pardoned him after he left office, so that was mooted.
Ew.
Well, Ford thought that the country should move on, so he pardoned him when he became president. So, yeah,
On
but
an ethical level, I do not approve. But not my country. I wasn't the president.
fair enough. So tactical does not believe in pardoning an ex-president until a trial or something, right?
Yeah, I think for me, I when I think about pardons, I think about you have already served your debt to society, and pardoning is a way to let you move on with your life. So the idea of this preemptive pardon so that you don't have to serve a punishment, um, that I'm a little more iffy on.
Well, I mean, the idea of pardoning people before a trial or before indictment's not unprecedented. I think it was President Carter who pardoned everyone who was a Vietnam draft dodger. So, I mean, all those people were pardoned for dodging the draft. So, you can definitely be pardoned
I
before
don't
you're.
mind that.
Yeah, see, that's so it's like, yeah, there is some precedent for that. And, should it ever come to pass that the United States passes some sort of meaningful marijuana reform, I would hope that a future president will pardon anyone for simple possession, whether we know who they are or not. So we call it just a blanket pardon. Let's pardon everybody. So it's like, that would be good. So I don't know if it was the right call or not. Ford was heavily criticized for it at the time, but it was what happened. Railway Hacker says, no, Harold Droit says, Harold Droit says, is Phoenix Wright Part 2 still coming? Man, we've done Part 2 and Part 3. And neither one did very well on my channel, although they're still there. I don't know if we'll do any more because the gameplay drove me more insane than the law, which is saying a lot because the law is horrible. But at least the law being horrible was fun. I got a little annoyed when I had to figure out what to click on and in what order. So we I don't know if we'll do any more, but parts 2 and 3 are available. Do I think President Warren will pardon Trump? Well, probably not. It depends who comes into charge next. I suppose if President Trump is successfully impeached and convicted, then President Pence will probably pardon President Trump. But we'll see what happens next. I don't necessarily see Warren being in a particularly eager mood to pardon Trump. No, I don't foresee that really happening.
I would have ethical issues with Pence pardoning Trump should that ever come to pass.
Yeah. Yeah. Well, it may come to pass one day. We'll see. Continuing. We also conclude that there was sufficient preliminary showing that each of the subpoenaed tapes contains evidence admissible with respect to offenses charged in the indictment. The most cogent objection to the admissibility of tapes conversations here is issued that they are a collection of out-of-court statements by declarants who will not be subject to cross-examination, and the statements therefore are inadmissible hearsay. Not that that matters that much at a grand jury proceeding. Here, however, most of the tapes apparently contain conversations to which one or more of the defendants in the indictment were a party. The hearsay rule does not automatically bar all out-of-court statements by a defendant in a criminal case. Declaration by one defendant may also be admissible against another defendant upon sufficient showing by independent evidence of conspiracy among one or more of the defendants, and a declaration if the declarations at issue were in furtherance of that conspiracy. The same is true of declaration of co-conspirators who are not defendants in the case. Recorded conversations may also be admissible for limited purposes of impeaching credibility of any defendant who testifies or any co-conspirator who testifies. So that's always a helpful thing to know if you're ever planning on testifying in your own behalf. If they can't bring the evidence in, they can still impeach you with it. So, like, say, for example, there is a tape recording of you making a confession, but the tape is thrown out and not being able to brought into evidence for some reason, okay? So then you get on the stand and say, I never did that thing. And then the prosecutor says, well, that's really interesting. I just happen to have this tape here, and I'd like to play it to refresh your recollection. And they play it. And the defense lawyer says, objection, this was excluded. And the prosecutor says, I'm not offering it as evidence. I'm offering it merely for the purpose of trying to refresh the recollection of the witness. Is the witness's recollection now refreshed? And we move on with our lives. And of course, the jury has heard this non-evidence evidence, so it doesn't really matter. But that's the rules for you. Don't lie under oath. Good tips.
Oh, wow.
Yeah.
Also, is now that you have this song about the hearsay exceptions going through my head, is conspiracy a hearsay exception?
Not unto itself, no.
Okay.
But what they're saying here is that a statement against party interest is a hearsay exception, and if you're part of a conspiracy, they're part of your party. So the idea is that this statement from this third person is a statement against your interest because they're a co-collaborator with you. So that's what they're talking about. Yeah. When in the rest just a capsule, it says the exception speaking through the statement. Good times. Here, however, there are other valid potential evidentiary uses for the same material, and the analysis and possible transcription of the tapes may take a significant period of time. Accordingly, we cannot conclude the district court erred in authorizing the issuance of the subpoena ducis tedium. Enforcement of a pretrial subpoena ducis tedium must necessarily be committed to the sound discretion of the trial court. That is a big statement of, we don't want a piece of this. The district court gets discretion. We're not going to look at it. We don't care. Please don't ask us. We don't want a piece of this. Go away. Fair enough. Since the necessity for the subpoena must also often determine upon determinations of factual issues. Without determination of arbitrariness or the trial court finding was without record support, an appeal court will ordinarily not disturb a finding that the appellant for a subpoena complied with the rule. Please don't ask us. We don't want a piece of this. In this case, however, where a subpoena is directed to the President of the United States, appellate review, in deference to the coordinate branch of government, should be particularly meticulous so as to ensure the standards of the rule have been correctly applied. From our examination of the material submitted by the special prosecutor to the district court in support of the motion for the subpoena, we are persuaded that the district court's denial of the president's motion to quash was consistent with the rule. We also conclude the special prosecutor has made a sufficient showing to justify a subpoena before trial. The subpoena materials are not available from any other source, and their examination and processing should not await the trial in the circumstances shown. Having determined that the requirements of the rule were satisfied, we turn to the claim the subpoena should be quashed because it demands confidential conversations between the president and his close advisors that would be inconsistent with the public interest to produce. This is where they're going to get into the executive privilege issue. The first contention is a broad claim that separation of powers doctrine precludes judicial review of a president's claim of privilege. The second contention is that if it does not prevail on the claim of absolute privilege, the court should hold as a constitutional law the privilege applies over the subpoena ducis tedum. In other words, there is a privilege called this executive privilege which exists and is more important than the subpoena ducis tedum. Okay, let's see what the court says. In performance of its assigned constitutional duties, each branch of the government must initially interpret the Constitution, and interpretation of its powers by any branch is due great respect from the others. The President's Council, as we've noted, reads the Constitution as providing an absolute privilege of confidentiality for all the presidential communications. Many decisions of the court have unequivocally reaffirmed the holding of Marbury versus Madison. That's pretty foundational, right? That it is emphatically the province and duty of the judicial department to say what the law is. No holding of a court has defined the scope of judicial power specifically regarding the enforcement of a subpoena for confidential presidential communications for use in a criminal prosecution, but other exercises of power by the executive branch and legislative branch have been found to be invalid as in conflict with the Constitution. We get to overrule stuff as being unconstitutional. Look at us and how awesome we are. In a series of cases, the court interpreted the explicit immunity conferred by express provisions of the Constitution on members of the House and Senate by the Speech and Debate Clause. Since this court has consistently exercised the power to construe and delineate claims arising under express powers, it must follow the court has authority to interpret claims with respect to powers aligned to derive from enumerated powers. Our system of government requires the federal courts on occasion interpret the Constitution in a matter at variance with the construction given the document by another branch. Deciding whether a matter has in any manner been committed to the Constitution by another branch of government, or where the action of the branch exceeds whatever authority has been committed, is itself a delicate exercise in constitutional interpretation and is the responsibility of this court as the ultimate interpreter of the Constitution. So you gotta love that clause right there, guys. That says that if there's a dispute over who gets the power, we get to decide who has the power. That's a baller move. You've got to love that one, right? Notwithstanding the difference each branch must accord the others, the judicial power of the United States, vested in the federal courts of the Constitution, can no more be shared with the executive branch than the chief executive, for example, can share with the judiciary veto power, or Congress can share with the judiciary the power to override a presidential veto. Any other conclusion would be contrary to the basic conception of separation of powers and checks and balances. We get the judicial power. It's all ours. All of it's ours. None of you guys can say otherwise. We have all the power. Ha ha ha. Look at us. Pretty awesome. We reaffirm that it's the province and duty of this court to say what the law is with respect to the claim of privilege presented in this case. In support of the claim of absolute privilege, the President's Council urges on two grounds, one of which is common to all governments, and one of which is peculiar to our system of separation of powers. The first ground is the valid need for the protection of communications between high government officials and those who advise and assist them in the performance of the manifold duties. The importance of this confidentiality is too plain to require further discussion. Yeah, fair enough. We need to have the ability to speak freely to power, right? Human experience teaches us those who expect public dissemination of their remarks may well temper candor with concern for appearances and their own interest to the detriment of the decision-making process. Whatever the nature of the privilege of confidentiality of presidential communications is in the exercise of the powers, the privilege can be said to derive from the supremacy of each branch within its own assigned area of constitutional duties. Certain powers and privileges flow from enumerated powers. The protection of confidentiality in the presidential communications has certain and similar constitutional underpinnings. The second ground asserted by the Presidential Council in support of absolute privilege rests on the doctrine of separation of powers. Here it's argued that the independence of the executive branch within its own sphere insulates the president from a judicial subpoena in an ongoing criminal prosecution and thereby protects presidential communications. Okay, both these arguments are pretty solid arguments, right? So on the one hand, we need executive confidentiality just generally. On the second hand, we have an independent executive with its own power, and therefore it is insulated from what other branches can do. These are both solid arguments. What does the court say? However, neither of the doctrines of separation of power nor the confidentiality of high-level communications without more can sustain an absolute, unqualified privilege of immunity from judicial process under all circumstances. The President's need for complete candor and objectivity from advisors calls for great deference for the court. However, when the privilege depends solely on broad, undifferential claim of public interest and confidentiality of such communications, a confrontation with other values arises. Absent a claim of need to protect military, diplomatic, or sensitive national security secrets, incidentally, those might be implicated in our current issue at hand, right? Because the current issue at hand deals with Ukraine and deals with what is going on there. So it might be argued by the executive, if this ever comes to pass, that this would fall into the scope of a claim of diplomatic secrets. So it may be that this case does not read on a future subpoena from the court, from the Congress, for exactly that reason, because they gave themselves an out. So that's their out. We find it difficult to accept the argument that even in very important interest of confidentiality in presidential communication is significantly diminished by production of such material for in camera, which is to say in chambers communication with the judge. It's just the judge alone, so they can see the documents privately, so they're not otherwise exposed while they're making a decision. In camera inspection with all the protection the district court will be obliged to provide. The impediment that an absolute unqualified privilege would place in the way of a primary constitutional duty of the judicial branch to do justice in criminal prosecutions would plainly conflict with the function of the courts in designing the structure of our government and dividing and allocating sovereign power among three co-equal branches. The framers of the Constitution sought to provide a comprehensive system, but separate powers were not intended to operate with absolute independence. While the Constitution diffuses power to better secure liberty, it also contemplates a practice that will integrate the dispersed powers into a workable government. It enjoins on the branches separateness, but interdependence, autonomy, and reciprocity. Citing Youngstown Sheet, which is also a pretty foundational case in constitutional power, goes with how much authority the president has at any given moment, given what the laws of Congress passes. Pretty interesting case, actually. To read the Article 2 powers of the President as providing absolute privilege against the subpoena essential to enforcement of criminal statute on no more than a generalized claim of public interest and confidentiality of non-military and non-diplomatic discussions, again, this is going to come up in a future subpoena in this case, I am sure, would upset the constitutional balances of a workable government and greatly impair the roles of the courts under Article 3. So let's see if there are any questions.
So, what I'm hearing, if I can try to summarize, is that the executive does have some sense of privilege and confidentiality, and part of that's just that the executive can function. They have access to top secret information, to diplomatic stuff. I mean, how a foreign country would talk to you might change if they think that that could be published at any moment. But it's not an absolute privilege, and that if there's a really good reason, you can override that.
Yeah, basically that seems to be what they're saying. So,
okay.
Yeah, you got it. Yeah. So for those of you asking, yes. No, Pelosi's next up. Pelosi comes before Grassley. For those of you wondering about the order, Speaker of the House is before President Pro Temp. So it's President, Vice President, Speaker of the House, then the President Pro Temp, and then it's the most senior cabinet position, which I believe, if memory serves correctly, is Secretary of State. And then it goes in order of the positions of the cabinet members. But yeah, Pelosi comes before Grassley. Speaker of the House comes first. So yeah, if both president and vice president are thrown out, then we might have our first female president after all, which I seriously doubt is going to happen. The Republicans are not going to allow that to occur. So I think President Pence is the most likely option if this goes this far. We'll see. Carrying on. Since we conclude that legitimate needs of the judicial process may outweigh presidential privilege, it's necessary to resolve those competing interests in a manner that preserves the essential functions for each branch. The right and indeed duty to resolve the question does not free the judiciary from a high accord to the respect of the representations made on behalf of the president. The expectation of the president to confidentiality of his conversations and correspondence, like the claim of confidentiality of judicial deliberations, for example, has all the values to which we accord deference for the privacy of all citizens, and adds to those values as necessary for the protection of public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making. The president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express privately. These are considerations justifying a presumptive presidential privilege for presidential communications. The privilege is fundamental to the operation of government and inexorably rooted in separation of powers. In a prior case, the Court of Appeals held presidential communications are presumptively privileged, and this position is accepted by both parties in the present litigation. We agree with Chief Justice John Marshall's observation, therefore, that in no case of his kind would a court be required to proceed against the president as against an ordinary individual. So, yes, the president is special. But this presumptive privilege must be considered in light of our historic commitment to the rule of law. This is nowhere more profoundly manifest than in our view when the twofold aim of criminal justice is that guilt shall not escape nor innocence suffer. We've elected to employ an adversary system of criminal justice in which the parties contest all issues before the court of law. The need to develop all relevant facts in the adversary system is both fundamental and comprehensive. The ends of criminal justice would be defeated if judgments were founded on particular or speculative presentation of facts. The very integrity of judicial system and public confidence in the system depends on full disclosure of the facts within the frameworks of rules of evidence. To ensure justice is done, it is neither imperative to the functions of the courts that compulsory process be available for the production of evidence needed by either prosecution or defense. Only recently, the court has reinstated the ancient proposition in law, albeit in the context of grand jury inquiry rather than a trial, that the public has every right to every man's evidence except to those persons protected by Constitution, common law, or statutory privilege. And that's a really interesting idea here because some of this court's analysis, it seems to me, would, with very minor exceptions, be applicable to other kinds of privilege, like attorney-client privilege, for example. It's like, what is the rationale for treating attorney-client privilege as near absolute? There are some minor exceptions, but I don't think they're as wide as the ones created here. So, anyways, it just seems a bit odd. The privileges referred to by the court are designed to protect weighty and legitimate competing interests. Thus, the Fifth Amendment to the Constitution provides that no man shall be compelled in any criminal case to be a witness against himself, and generally an attorney or priest may not be required to disclose what has been revealed in professional confidence. These and other interests are required by law and privileges against forced disclosure established in the Constitution by statute or common law. Whatever their origins, these exceptions to demand for every man's evidence are not lightly created nor expansively constructed for their derogation of the search for truth. And fair enough, every court everywhere will tell you that privileges are to be construed narrowly. In this case, the president challenges the subpoena served on him as a third party requiring production for materials used in criminal prosecution. So that answers your earlier question, Tactical. The president was not being indicted. He's a third party. So someone else is being indicted, and it's evidence in some other investigation. So, yeah. He does so on the claim that the privilege has disclosure of confidential communications. He does not place the claim on the ground that they are military or diplomatic secrets, like would be applicable here. As to these areas of the duties, the courts have traditionally shown the utmost deference to their presidential responsibilities, dealing with presidential authority in foreign policy considerations. The president, both as commander-in-chief and as the nation's organ for foreign affairs, has available intelligence services whose reports are not and ought not to be published to the world. It'd be intolerable that the courts, without relevant information, should review and perhaps nullify actions of the executive taken on information properly held secret. In United States versus Reynolds, dealing with the claimant demand for evidence in a tort claim act against the government, the court said it may be possible to satisfy the court from all the circumstances of the case that there's a reasonable danger that the compulsion of evidence will expose military matters, which, in the interest of national security, should not be divulged. When this case is, the occasion for privilege is appropriate, and the court should not jeopardize the security with which the privilege is meant to protect by insisting upon examination of the evidence, even by the judge alone, in chambers. No case of this court, however, has extended this high degree of deference to the president's generalized interest of confidentiality. Nowhere in the Constitution, as we've noted earlier, is there any explicit reference to a privilege or confidentiality, yet to the extent this interest relates to effective discharge of presidential power, it is constitutionally based. The right of production of all evidence in a criminal trial similarly has constitutional dimensions. The Sixth Amendment expressly confers on every defendant the right to a criminal trial, the right to be confronted with witnesses against him, and to have compulsory process for obtaining witnesses in his favor. Moreover, the Fifth Amendment also guarantees no person shall be deprived of liberty without due process of law. It is manifestly the duty of the courts to vindicate those guarantees and accomplish that is essential to the relevant and admissible evidence that must be produced. In this case, we must weigh the importance of the general privilege of confidentiality in presidential communications and the performance of the presidential responsibility against the inroads of such a privilege in the fair administration of justice. The interest in preserving confidentiality is weighty indeed and entitled to great respect. However, we cannot conclude that advisors would be moved to temper the candor of their remarks by infrequent occasions of disclosure because the possibility that such conversations will be called for in the context of criminal prosecution. On the other hand, the allowance of the privilege to withhold evidence that's demonstrably relevant in a criminal trial will cut deeply into the guarantee of due process of law and gravely impair the basic functions of the court. A president shall acknowledge the need for confidentiality in the communications of his office is general in nature, whereas the constitutional need for the production of relevant evidence in a criminal proceeding is specific and central to a fair adjudication of a particular criminal case in the administration of justice. Without specific access to facts, a criminal prosecution may be frustrated. The presidential broad interest in confidential communications will not be vindicated by disclosure of a limited number of confidential conversations preliminarily shown to have some bearing on a pending case. We conclude that when the ground for asserting privilege as a subpoena material sought for use in criminal trial is based on only a generalized interest in confidentiality, it cannot prevail over fundamental demands of due process in law. For criminal justice, the generalized assertion of privilege must yield to the specific need for evidence in a pending criminal trial. So that is about all there is on executive privilege as far as that goes.
So they're saying that the best way to overrule executive privilege is by showing that it's essential and specific to that criminal matter. So you can't go like on a fishing expedition, but if you know something exists and it's central to being able to proceed with the case, then you can ask for it because you've provided a bunch of justification.
Now, what's interesting here for me is that all this is relating to the special prosecutor who is an executive branch official. So again, you could make a differentiation on this case versus Congress. So you could make a distinguishment that if Congress is requesting information, it is different somehow than if another member of the executive branch is requesting, because Congress doesn't do criminal law. Everything they do is political. Stuff they uncover can be used criminally for sure, but they don't do criminal law. So the rationales that apply here when it comes to criminal justice don't necessarily apply to Congress, because what Congress does is not criminal. So you can make a differentiation based on that. So if Congress attempts to subpoena certain information, the president says nah, they have at least two arguments that we've seen so far. They can argue it relates to diplomatic matters, because it clearly does. So like Congress might want to subpoena other diplomatic conversations the president has had, and he could say quite legitimately, well, these are diplomatic matters, therefore they're excluded out of this case. And I think he'd be right. You could also argue that the Congress is what they're doing is not a criminal prosecution. I'd be right. So he has two lines of argument, seems to me, for some confidentiality. So, yeah.
For me, and I understand that this is more philosophical rather than legal, but if the DOJ's position is not to indict a sitting president, and in order to impeach the president, you have to present evidence, but the president can block you from obtaining evidence. It creates this like circle of, chasing your own tail, because the only way that you can command the evidence is through a criminal proceeding. But you can't proceed with the criminal proceeding until you have the impeachment. And I don't like the catch-22. So if Congress and the courts agree that Congress doesn't do a criminal thing, and therefore they can't override this executive privilege, then I think the DOJ needs to be willing to proceed with criminal indictment before impeachment.
Yeah, fair enough. First, totally off topic. Hi, Nate Brody. I just recently discovered your channel, and I saw you on Viva Fries with a co-thing that you guys did. So I really wanted to let you know I liked it and thought it was wonderful. So thank you for being a member of the channel, and glad that you love it. And I'd love to talk to you sometime. Back to your question, though, because that they can't indict the president has no bearing on their ability to indict hordes of other people. For example, it has been suggested that Attorney General Barr or Rudolph Giuliani might want to be criminally tried for some of their actions. So you could hypothetically find a prosecutor who's wanting to bring charges against those people, and those tapes might be relevant to that, and therefore you could bring it out that way. So yeah, just because you can't indict the president doesn't mean that you can't indict other people ancillary to the president and get the information that way, and Congress could get it from the executive branch. So, if there's a U.S. attorney out there that wants to subpoena this information, then the rationales would change. And if they find it, then hypothetically, they could turn it over to Congress as part of the oversight. So that could be exciting and fun for everyone. Can the Supreme Court compel it? That's exactly what we're talking about in U.S. v. Nixon. This is exactly what the case is about the ability of the Supreme Court to order things to be compelled. And it says, as we've been reading it, that if it's in a criminal case by the special prosecutor, that they can compel it because it relates to due process guarantees, it relates to right to subpoena evidence, have your witnesses be available to be confronted, and other things that come with a criminal prosecution. The problem is, as we were discussing, that whatever Congress is doing, it's political. It's unavoidably political. It's not criminal. It can't be. Even in an impeachment, their power is limited to throwing you out of office and telling you can never have a job again. That's it. They can't do anything else. So all their power is political. They can deny you the job you have and deny you from ever having another job. That's all. And so nothing they do can potentially be criminal. So the logic of this case doesn't quite apply to what Congress might want to do. So there's two grounds of differentiation there. And as Tactical points out, the fact that the president is immune from indictment might be a problem. Although, again, this is an issue where the attorney general seemed to suggest that Mueller was wrong, that he couldn't make a determination on the criminal case. Because you remember Mueller said that he could not even come forward with a determination as to whether or not a crime had been committed. The attorney general said that was wrong, and he could have. He just couldn't indict. One of the things grand juries do, other than indictments, is investigate. They have other powers, just other than investigating. They can do investigations for other purposes. So hypothetically speaking, I suppose you could compel a grand jury to do a criminal investigation, not to indict, just to investigate, and then it would be a criminal investigation a la the police, and then they could get information for the process of justice. So I guess it would depend on how ballsy a prosecutor is somewhere, whether or not they want to do any of those things. So, yeah. You can ask more questions if you have more questions.
Was that the third option that Congress has?
No, we have not gone that far yet.
Okay.
All right. So this is something I found out about just today in doing research for this case. I did not know that this is a thing that existed. Because when Congress is upset that the executive is not giving them information, they have traditionally had two powers. One, they can refer a criminal case of contempt for contempt of Congress. The problem there is that the executive branch gets to decide who to prosecute. And of course, they're not going to prosecute themselves. They also have a civil power where they can go to court and ask for things civilly. The problem there is twofold. A, it takes a long time, and B, courts still decline to hear a lot of these cases because of the political nature of them. They don't decline to hear all of them, but they do decline to hear some because of the political issue. But there is option number 3, which we're going to discuss, that I just learned about today. Today I learned. The current dispute between Democrats in the House of Representatives and Attorney General William Barr, this was going back to May when this was a thing, but will be relevant to our current issue, could result in contempt. So what contempt powers does Congress possess that they can use? The House Judiciary Committee is considering issuing a contempt citation against Barr. In turn, the Justice Department has said the House subpoena does not serve a legitimate legislative purpose. Yeah, we're going to subpoena you and hold you in contempt, and then we're going to hold you in contempt, and you're the Attorney General, and you have to decide whether to prosecute yourself. We know how that's going to go. Based on precedent, statute, and court rulings, the House and Senate each have power to invoke three kinds of contempt proceedings. I was only aware of 2. We're going to learn about number 3. We'll just skip ahead. The third type of contempt power, Congress's dormant inherent contempt power, is rarely used in modern times. Inherent contempt was the mode employed by Congress to directly enforce contempt rulings under its own constitutional authority until criminal and civil contempt statutes were passed, and it remained in use into the 20th century. Under inherent contempt proceedings, the House or Senate has its sergeant at arms or deputy take the person into custody for proceedings in Congress. So apparently, under case law and under statutory law, Congress can authorize the sergeant at arms, who is a legislative official, to arrest someone and hold them until the trial. And I found out they used to have a jail in the basement of the Congress building. It's been since turned into office space, but they used to have a jail down there, and you could put someone in that jail by legislative fiat. Apparently, this is a thing that used to exist up until like the 1920s was the last time it was used. So I did not know this was a thing. So hypothetically speaking, Congress could issue a subpoena to, say, Rudy Giuliani, and Rudy Giuliani could refuse, and they say, we're holding our inherent contempt power. And then they tell the sergeant at arms, who again is a legislative official, to go and arrest him and drag him down to the basement and lock him into an office, I guess. So that's a thing that could happen. I thought that was entertaining.
Oh, wow. But that might look bad on Congress.
It might look bad. I'm just saying this is an option that existed. I was unaware that this is an option. Let's see if there's any more. Although these powers are not directly stated in the Constitution, the Supreme Court has ruled on multiple occasions they're implicit as an essential legislative power held by Congress. Justice Willius Van Devanter perhaps made the most famous statement of these powers in McGrain versus Doughty, a 1927 Supreme Court decision about Mally S. Doughty, the brother of the former Attorney General Harry Doughty. A select Senate committee issued a subpoena for Doughty to testify and also surrender records from an Ohio bank. When Doughty refused to comply after the second subpoena, the Senate passed a resolution issuing a warrant and authorizing the Senate deputy to take Doughty into custody. Doughty filed a habeas proceedings against his detention. A lower court ruled that the Senate had exceeded its powers by detaining Doughty, freeing him. However, the Supreme Court upheld the conviction, holding that under the Constitution, Congress has the power to compel witnesses and testimony to obtain information in aid of the legislative function. So the U.S. Supreme Court has ruled that the United States Congress can unilaterally arrest someone on their own initiative. This is a thing that apparently exists. I did not know. Each House of Congress has power through its own process to compel a private individual to appear before one of its committees and give testimony needed to enable it to efficiently exercise the legislative function brought under the Constitution. This has long supported in the Houses separately and repeated acts of Congress, all amounting to a practical construction of the Constitution. Tactical.
So when Lewandowski testified before Congress, he frequently invoked executive privilege and said, I've been advised not to answer questions about my conversations with the president because it could fall under executive privilege. And Congress was very not happy with that. And in fact, they were sort of saying that because he was never an employee of the executive,
Right.
and he was not officially doing any executive related duties, that his conversations would not fall under executive privilege. Now, I didn't hear anything in that Supreme Court ruling about limiting that privilege only to employees for the executive or government officials. After reading that ruling, do you have any opinion on whether executive privilege would apply to unhired, unpaid advisors that are not employees?
Well, I have mixed feelings on the issue because on the one hand, like everyone who is a federal official has to take an oath of office and the oath to the Constitution, right? So there's an idea that every member of the US government is bound to obey the Constitution. And so you could say that every member of the executive branch and cabinet officials is implicitly aware of their responsibilities to the president and would not just repeat them willy nilly. If you brought in a random, if they brought in a random third party, if they brought in you, to have a conversation with the president, the idea that you might tell people what happened is not absurd because you don't have any particular like loyalty or duty. You're not even an American citizen. So like that's my dominant answer. There is a contra idea in my mind that the president might want advice from someone who's not in his inside his government, because the president might have a special issue and he might want special advice from a specific person for some reason. So like, well, maybe he should have that, but if that other person, tells about it, then like where's the privilege imply? Because, privilege requires both people to like be aware, at least in some level, that there is a secrecy. And if the other person, I mean, I guess the president could whisper to you, this conversation's secret, please don't tell anyone. So I don't know how that would play. I mean, the court case doesn't deal with it. It hasn't come up. Now,
Okay.
Rudy Giuliani's argument is going to be attorney-client privilege, but the problem there is it's not 100% clear to me that Rudy Giuliani has necessarily been acting in the capacity as an attorney. Just because you're an attorney doesn't mean everything you do is attorney-client. I'm an attorney. I'm talking to you. That doesn't make what we're doing attorney-client. Not for at least the reasons that a lot of people are listening, and third party shatters the privilege if it existed, which it didn't anyway. But it's like, you don't need to be an attorney to have a conversation about the law. So it's like this is not, attorney gives me knowledge, but it doesn't make this an act of an attorney. So a lot of things Rudy Giuliani has been doing are not things attorneys do. So you can make a credible argument that some or all of what he's doing is not covered by attorney-client privilege, which will be hilarious if that ever comes to be.
Now, this is more of an ethics question rather than a constitutional one. But Giuliani said that he is not paid for the services that he provides to the president. If you are a lawyer doing pro bono work, do you still have obligations to keep timesheets, to have records of what law work you are doing for your pro bono client the same way that you would if a client was paying?
I mean, not necessarily. The only reason that you would want to do that is if you think that there's a probability of you getting paid on the back end, because some of the statutes allow for attorney's fees to be awarded. So if you're in a domain where attorney's fees can be sought, then even if you're pro bono, you could ask for attorney's fees, and so you can keep timesheets to show what you're doing. You're not going to recover from your client, but if you can recover from the other guy, or by statutory rule or something else, then you keep timesheets for that. I'll just put it this way: I've done pro bono work, and the pro bono work I did, I never kept timesheets because I wasn't planning on charging anyone. There was no hope of me getting money from anybody. So the few times it came up for me, I didn't keep timesheets because why would I? I'm not billing anybody. Yeah. So, anyways, that is the end of this case. So, Tactical, if you want to leave, you can. Unless you have more questions, which we'll be happy to entertain your questions.
No, that was pretty much all of them.
Excellent.
I hope everyone feels more informed on what executive privilege is, why it is, how it is, and mostly just know that there's very little case law and it's going to be a shit show no matter what.
Yep, that's about right. That's definitely correct. It's gonna be a shit show on levels. So I think the House will probably impeach. They'll probably impeach by the end of the year, so by December 31, and the Senate will have its trial in January, February, and we'll see what happens next, I guess. So fun. All right, let's move on with life. Oh, this is going to be a good one, actually, because it rolls very well into the conversation we were just having. We get to talk about executive privilege kind of indirectly some more. For our story, we have the case of Bilal Abdul Karim versus Gina Sherry Haspel, the director of the Central Intelligence Agency. So, Mr. Karim has been in overseas, and a number of times he has been remarkably close to places where bombs are being deployed, apparently aerially. And he's suspected that maybe the U.S. government is trying to kill him. And he'd like to know if the U.S. government is trying to kill him. And the U.S. government went to court and said, you can't know whether or not we're trying to kill you because that comprises a military secret. And therefore, it's something we're not going to tell you about. And the district court said, you're right, it's a military secret. And therefore, it's not something we're going to tell you about. We're not going to tell you whether or not they're trying to kill you or not. Sucks to be you. So we're going to read this decision and see what the district court has to say. What constitutional right is more essential than the right to due process before the government may take a life? While the answer may be none, federal courts possess limited authority to resolve questions presented in a lawsuit, even where they allege to involve constitutional rights. This is such a case. Despite the serious nature of plaintiff's allegations, this court must dismiss the action pursuant to the government's invocation of state secret privilege. Plaintiff Bilal Abdul Karim is a journalist specializing in reporting on terrorism and conflict in the Middle East. Mr. Karim has been the victim or near victim of at least 5 aerial bombings while in Syria. Accordingly, he believes his name is on a list of individuals the United States has determined are terrorists and may be killed, the so-called kill list. Mr. Karim sues the director of the CIA, the Secretary of Defense, the Secretary of Homeland Security, the Attorney General, and the Director of the National Intelligence, all in their official capacities, as well as Department of Justice. The court previously granted in part and denied in part defendant's motion to dismiss for lack of standing and failure to state a claim. Defendant now moves to dismiss Mr. Karim's remaining claims pursuant to state secrets privilege, arguing the facts necessary for Mr. Karim to establish his prima facie case or for defendants to defend against his claim are classified, and without disclosure of the facts, the case cannot proceed. Having carefully considered the issues, the court agrees. So if the government is trying to kill you, they're not going to let you know. The facts are described in detail in the decision on defendant's first motion to dismiss, so they'll be repeated here only as relevant. After the court permitted 3 of Mr. Karim's claims to proceed, the parties discussed potential pretrial resolution. Despite 2 months of discussions, the parties were unable to resolve. Mr. Karim then asked to begin discovery, and defendants notified the court they were considering a second motion to dismiss based on state secret. After considerable time, due to multiple motions for extension of time and excessive government shutdown, defendant filed a motion to dismiss pursuant to state secret privilege. The motion is ripe for review. The United States is privileged to refuse to disclose information required in litigation when there is reasonable danger the disclosure will expose military matters which, in the interest of national security, shall not be divulged. The privilege is not likely invoked, but courts should accord the utmost deference to executive actions of privilege upon grounds of military or diplomatic secrets. Quoting United States versus Nixon, the case we just read earlier. Review of invocation of state secrets privilege occupies 3 steps. First, there must be a formal claim of privilege lodged by the head of the department, which has control, after actual personal consideration by that officer. Next, the court must evaluate the basis of the privilege without forcing a disclosure of the very thing the privilege is designed to protect. The sensitivity of the privilege and the information at issue requires the court to review declarations submitted, both publicly and in camera, which is to say in chambers, to determine if the privilege is properly invoked. The court must satisfy from all the evidence and circumstances and from implications of the questions in a setting which is asked, the responsive answer to the questions or an explanation of why it cannot be answered might be dangerous because injurious disclosure could result. If a court is so satisfied, the claim of privilege will be accepted without further disclosure. It's not necessary for the court to examine actual evidence made in this determination. As we read in the U.S. v. Nixon case, even in-camera inspection of state secrets is not permitted, and that's exactly what they're talking about here. Finally, once the court finds that there's a reasonable danger that disclosure of information will expose military matters or harm national security, the court must determine where the case may proceed without information of whether it is so entwined in the matter that the case cannot be litigated and dismissal is necessary. The government has satisfied the 3 procedural requirements for invoking the state secret privilege. First, the privilege was asserted by the United States government itself and not a third party. Second, the claim of privilege was made through a formal declaration by the heads of the agencies responsible. The acting Secretary of Defense and the Director of National Intelligence submitted formal declarations, both public and in-camera ex parte explanations explaining that they're individuals responsible for the relevant information and invoking the privilege. Third, the acting secretary and director both declared they personally reviewed the information and determined state secret privilege was warranted. When properly invoked, the state secret privilege is absolute. No competing public or private interest can advance to compel disclosure of information found to be protected by a claim of privilege. Due to the absolute nature of the privilege, a court must not merely unthinkingly ratify the executive's assertion of absolute privilege, lest it inappropriately abandon its important judicial role. The government is required to show disclosure of the information poses a reasonable danger to secrets of state. Other claims of privilege can also be overcome when necessarily presented by the requesting party outweighs the privilege, but such is not the case where state secrets would be disclosed. Instead, the degree of necessity determines how far the court should probe into satisfying itself for the occasion invoking the privilege is appropriate. Where there's a strong showing of necessity, the claim of privilege should not be lightly accepted, but even the most compelling necessity cannot overclaim the claim of privilege if the court is ultimately satisfied military secrets are at stake. Therefore, the critical feature of the inquiry in evaluating the claim of privilege is not a balancing of ultimate interests at stake. The balance has already been struck. Rather, the determination is showing whether the showing of harm might be reasonably seen to flow from the disclosure is adequate in a given case to trigger the absolute right to withhold the information sought in the case. So the president may not have an absolute right to keep his secrets secret, but the CIA does, just in case you wanted to know. Mr. Kareem's claim involves allegations that the United States targeted an American citizen for lethal action in a foreign country without due process of law. His need for information to prove his claims is unquestionably strong. Thus, close examination of the government's assertions is warranted. The government invokes the state secret privilege to protect the existence and operational details of alleged military and intelligence activities directed at combating the terrorist threat to the United States. Mr. Kareem specifically requests discovery into whether or not the United States has in fact targeted Kareem for lethal force, and if so, the facts on which the government relies, what process the government used to designate him, and if it continues to designate him, and whether or not the United States attempted to kill Kareem in the airstrikes alleged. Based on a review of the public and classified declarations, the court finds the information Mr. Kareem asked for constitutes privileged state secrets because there's a reasonable danger that disclosing such information would endanger national security. Detailed statements underscore the disclosure of privileged information and the means, source, and methods of intelligence gathering in the context of the case would undermine the government's intelligence capabilities and compromise national security. The government explains that disclosure of whether an individual is being targeted for lethal action would permit the individual to alter his behavior to evade attack, or could capture and could risk intelligence sources and methods if an individual learns he's under surveillance. I'm not quite sure how that's true when it comes to like aerial surveillance. I'm not quite sure, like, knowing that if I knew for an active fact that if I was overseas, I was being surveilled, I'm not quite sure what I could do to prevent that from happening, because they're surveilling me from air and satellites and whatever. So I'm not sure what I could do, but okay. Acting Secretary Shannon states in his public declaration that disclosing classified information about targeted airstrikes could hinder the United States military operations, and disclosing whether the United States possesses information about a particular individual could alert them, allowing them to prevent further collection and risk disclosure of intelligence sources and method, thereby thwarting intelligence officers. I'm not quite sure how it risks disclosure of intelligence sources and methods to say, yes, your name is on the list. It might preclude further collection because they might not want to go overseas anymore, but, you know, okay.
No, I could see a way.
Oh, yeah?
So, like, yeah. So, if I know that there's only one reason why the US government would want me dead, and then I find out that the US government wants me dead, then I know that they are aware of my activities. So either there is a mole or an informant, or that project, I'll call it, has like cats out of the bag. So then I can then go and warn any co-conspirators that I have, like, the US knows what we're up to. Flee.
Okay.
And yeah.
All right. I can see a potential context where that could come up. I understand your point. Yeah. But I do love love is exactly the wrong word. I do, what's the word I want? Hate deeply the fact that this is a United States citizen who's apparently being targeted by our government, who like 5 or 6 times bombs have gone off near him from aerial bombs. I mean, the fifth time would be a clue to me that maybe someone doesn't like me. That might be a clue to me that something might be up. So yeah, yeah. And then I sue them, and they say, well, we're not going to tell you if you're on a list because that's a state secret. And the state says, go away.
Well, could you imagine if um, they confirmed if you were not on a list, but then said, oh, we can't tell you if you're on a list if you were on a list? So, like, he might not be on
Yeah,
a list.
that's
But
fair.
if they confirm that he's not, then that means just anybody gets to sue and says, am I on the list? And then whoever they don't answer, they go, ah, I'm on the list.
Right, exactly. So that is an extremely fair point. I would potentially differentiate when it comes to United States citizens versus random people in the world versus we're not going to tell you, we're not going to. The CIA does love the we're not going to confirm or deny, because even denial would tell you something. So they do love that. Yeah, the Glomar, we can neither confirm or deny. Exactly correct. Thank you, Evil Tribble. They do love that, but I don't know. When it comes to U.S. citizens, I don't know. Here's the operative question: like, should any U.S. citizen's name be on the "we're going to kill you" list? I guess if you're in active combat against the United States, maybe. But then again, you're probably not petitioning the courts to find out if you're on a list. So I don't know. I don't want to be on a list. Please don't kill me, government. I'm sorry for everything I ever said. But your point is well taken. If they deny people are on the list and then other people ask and say we're not going to tell you, it would tell you that you're on the list. Yes, your point is well taken. It's like going to a doctor and asking, is so and so your patient? If they say no, then no. If they say I can't tell you, the answer is yes. So yeah, there is a bit of a conflict there, which is incidentally like why pure names is not considered privileged in most contexts. Anyways, carrying on. Director Coates similarly declared that disclosing whether the United States targets terrorists aboard with lethal force could reasonably be expected to cause harm to national security by alerting terrorists and terrorist organizations to specific means the U.S. government is using or is not using to combat terrorism. I think everyone's pretty familiar with the drone program at this point. I think everyone's got the memo. Confirming or denying whether Mr. Kareem has been designated for use or lethal force could permit him to evade capture or further action by the United States. Are we trying to capture him? Like what? Disclosing whether the United States maintained information about Mr. Kareem could reveal sources and methods by which the information was obtained. That's fair. That's fair. If the only way they got the information is from people who are being monitored for very legitimate reasons, that's potentially a fair point. Compromising the safety and effectiveness. Mr. Kareem raises 4 points against allowing the privilege to apply. First, he argues the constitutional right at issue, his right of due process before the United States can take his life, is so paramount as to make the state privilege inapplicable. Not the worst argument I've ever heard. Second, he asked the court to consider alternative methods of protecting information, such as the use of the Classified Information Procedures Act, to ensure the classified information is not disclosed outside cleared counsel and the court. So, incidentally, there are ways for the court to consider classified information so that it can consider things when these cases come up, so that the judges don't have to be specifically cleared, so they can see the classified stuff. So Congress thought about that and has written laws to that effect. Third, Mr. Kareem challenges the assertion that all the information remains privileged because the United States has previously disclosed that U.S. citizens were targeted with lethal action. Finally, he differentiates his request for ad hoc relief, review of the alleged decision to target him with lethal force, with prior state privileges cases which requested post hoc relief, challenges to action which could not be further prevented or undone. Mr. Kareem's first objection focuses on the significance of the right at issue, his right of due process, evidence and argument for the United States can take his life. But the state secret privilege is absolute. That's troubling. Invocation of the privilege has serious potential to defeat worthy claims of violations of rights that would otherwise be proved. It is for this reason the privilege is not to be lightly invoked. Incidentally, while I'm thinking about it, when it comes to attorney-client privilege, there is a well-worn exception. I'm pretty confident is in every state that if you know that your client is about to like kill someone, you can disclose that. So even attorney-client privilege does not extend to my client is about to kill somebody. I can call. In fact, I have to call the police and inform them of this. So just saying that the government has a wider privilege than I do. So that's a thing, man. The government did not rush to claim state secrets here, although it warned state secrets were at issue. It only filed the instant motion when the court first denied its original motion. The court finds the government has not invoked the privilege lightly, but has instead engaged in months of consideration before filing its motion, supported by reasoned declarations from heads of agencies responsible. Nonetheless, the significance of the allegations requires the court to take a thorough and questioning look at the reasons for invoking the privilege, but it does not erase the privilege altogether, or in any respect whatsoever, apparently, if it's absolute, one would think. While no court has previously addressed the state secret privilege in the context of a targeted killing, courts have addressed the privilege in cases involving other constitutional claims. The privilege has been invoked in cases involving warrantless surveillance. Let's see. I'm trying to find out where the parentheses start and stop. I'm just going to skip that paragraph altogether. Next, Mr. Kareem probes the limits of the state secret privilege and likens his predicament to a criminal trial. Based on the analogy he requests, the court institutes the CIPA rules to protect privileged information rather than excluding it altogether. In a criminal trial, the government may not withhold information that would be material to the defense even if it's a privileged state secret. To do so would deprive the defendant of liberty without due process. The United States may either proceed with the indictment and disclose the information or forego prosecution. However, the Supreme Court has held when the government is not the movement in the civil case, the rationale in criminal cases is not applicable. Fair. It's different in civil versus criminal. Yep. Mr. Kareem specifically equates his situation with a criminal capital case, which extra procedural protections are provided to the defendant to ensure the punishment is not meted out arbitrarily or capriciously. He argues before a criminal defendant may be subject to capital punishment, he has the opportunity to review and potentially dispute a fulsome record of allegations and considerations that will be used against him. He asks this court for the same protection because he fears the United States military will kill him. Were the United States to choose to prosecute Mr. Kareem for his alleged involvement in terrorist activities, the government would be required to disclose with relevant protections any classified information that be material. But Mr. Kareem is not a criminal defendant, is a plaintiff in a civil suit against the United States, which renders the state secret privilege absolute after it's properly asserted. Okay. I would note that by the court's own logic in describing this as absolute, it presumably would apply if the CIA was trying to kill a United States citizen who was inside the country at the time. Like, the way this is written, one would imagine that if the CIA kicks down my door and shoots me, but I know about it in advance, that I still can't get access to that information. So, like, I'm just plumb out of luck if the CIA chooses to commit a covert op against me, even though I'm a United States citizen. That somehow troubles me on several levels, since it can obviously be used to take out people who are just mere political dissidents. I don't know what Mr. Kareem's issues are. I don't know whether or not he's involved in terrorism or not, but this is a little unsettling to me because I don't want the U.S. government to just kill me for the hell of it. Third, Mr. Kareem challenges the legitimacy of the privilege because the United States has previously disclosed the existence of the kill list and indicated United States citizens has been on the list. Quoting, President Barack Obama and Attorney General Eric Holder have admitted the United States targeted and killed Anwar al-Awlaki, a terrorist who was a key leader of al-Qaeda in the Arabian Peninsula, who I suppose was a U.S. citizen at the time. Mr. Kareem challenges the legitimacy of invoking the state secret privilege here because the United States previously determined its security interests allowed the disclosure of a name on the kill list. Contrary to Mr. Kareem's argument, the D.C. Circuit has already found the government is not stopped, which is to say barred, from concluding in one case the disclosure is permitted, while in another case not. The court holds that a previous U.S. disclosure that an individual has been targeted does not mean the U.S. has waived its right as to a state secret to refuse to disclose the who, what, why, and how it might identify future targets. So tactical, if they're after you, I guess you are also similarly out of luck. So, yay.
Well, I think so. CIA deals only with foreign stuff. They're not supposed to operate within the U.S.
They're not supposed to, no. No, that's true. They're not supposed to operate within the U.S. I agree. Neither is
And
the
you're having some doubts over whether they have sufficient oversight to prevent that from ever happening?
the NSA is also not chartered for domestic surveillance, and yeah, uh, I'm having doubts. Yeah, yeah, and also like I suppose the CIA could call up one of its friends in another intelligence agency and have them come over here and shoot me, as a trade. So there's that. So the CIA can plot to kill me by having whatever the CIA equivalent of, I don't know, pick your country of choice, come over here. Ukraine, maybe. The Ukrainian CIA come over here and shoot me.
And then they'll call it like interagency cooperation
And diplomacy too. It's
and
military
give
and
themselves a
diplomacy.
pat on the back.
So we got two exceptions to the to US v Nixon there. It's both diplomatic and military at the same time. Excellent. I feel assured. Finally, Mr. Cream argues the prospective nature of his case differentiates his dilemma from previous cases dealing with state secret privilege. He maintains that none of the cases involved the prosecution of a U.S. citizen or any action analogous to prosecution. In this assertion, he is correct. He is a U.S. citizen voluntarily in Syria, reporting on fighting by insurgents and alleged targeted by the United States without success so far. However, the applicability of state secret privilege has been constantly recognized in civil litigation against the United States, even when a plaintiff was allegedly violating constitutional rights, which is exactly what the instant lawsuit entails. Yes, the U.S. government can violate your constitutional rights as long as it's state secrets. Great. The court understands the difference between this and prior cases, but the similarities are controlling and require the same conclusion. A court does not merely ratify the government's assertion of privilege willy-nilly, which I suppose is good for the court because then they won't come after you, I guess, so there's that. This court has reviewed declarations submitted by the government and carefully considered Mr. Cream's claims and need for documentations, as well as the reason behind the privilege. Consistent thereto, the court finds state secret privilege bars disclosure of required information to Mr. Cream because disclosure would present a reasonable danger to national security. Okay. There's still a question as whether the unavailability of the requested information is fatal to the complaint. Whether it's fatal to Mr. Cream is no longer a question. Ha ha ha. A court must dismiss the case in which a privilege of state secrets is sustained, where the disclosure is necessary for the plaintiff to make its prima facie case, disclosure is necessary for the defendant to defend itself, or further litigation will present an unjustified risk. The United States focuses on Mr. Cream's prima facie case, arguing Mr. Cream cannot establish its standing to sue without the information. The court agrees and notes all three reasons justify dismissal. Because there's no feasible way to litigate the alleged liability without creating an unjustified risk of divulging state secrets, the case must be dismissed. The claims and possible defenses are so infused with state secrets that the risk disclosing them is both apparent and inevitable. To prove his prima facie case, Mr. Cream must be able to show he was in fact targeted by the United States with lethal force. The court previously found Mr. Cream's alleged facts sufficient, if proven, to survive a motion to dismiss, but having now held the government is not required to disclose whether Mr. Cream has been targeted as alleged, it's impossible for Mr. Cream to obtain the information necessary to prove his claims. They're all just coincidental so far. Lots of coincidences. Without access to the privileged information, Mr. Cream is unable to establish whether he was targeted by lethal force or what information was considered in reaching the alleged decision to target him. Mr. Cream is incapable of demonstrating he sustained a violation of his constitutional rights without the withheld information. That's cute. Wow. He is alleged but ultimately cannot show a concrete injury amounting to either specific present objective harm or threat of specific future harm. The several previous attempts to bomb him apparently do not qualify. In this instance, which is relevant information solely in the control of the United States and is protected by state secrets, Mr. Cream is left with no method to obtain to pursue its case, which therefore must be dismissed. The same analysis applies to the government's ability to defend itself. When a plaintiff's prima facie case and defendant's defenses are not affected by state secret, the court must still dismiss if any attempt to proceed will threaten the state's secrets. In that circumstance, the risk of disclosure alone leads to dismissal. The analysis applies here. The totality of issues to be litigated surrounds the alleged decision to target Mr. Cream, but all such information is privileged in the state secrets and will not be disclosed by the United States. With no hope of a complete record and adversarial deployment of the relevant issue, the court cannot even begin the inquiry. The complaint must be dismissed. For the foregoing reason, the court will grant the motion to dismiss. Okay. So that is the story of Mr. Kareem and the CIA. So I guess the operative lessons here are that state secret privilege is absolute. And so that ties in very nicely with our discussion from US v. Nixon about some of these privileges. So diplomatic privilege and military privilege are currently held as absolute. So that will help Trump in his case. But more to the point in the instant issue, for Mr. Kareem, I guess stay out of Syria is all you can do because, yeah, it seems like the US government may have a thing for you. And if you've already been bombed 5 times, maybe it's time to not do that anymore. I have no other advice for you because apparently there's no redress in the courts to be had. So, good luck, sir. I hope all's well. I've got nothing more to say about that. Lord. Yeah, I love what Evil Tribble says here. No rights are absolute, but certain government powers are absolute. That's a very, very fair counter. That's an extremely fair counter. How many times have we heard that freedom of speech is not absolute or right to bear arms is not absolute? I'm hard pressed to think of any right that's absolute. And yet there are certain powers that apparently are absolute when it's done by the government. Well, it does go into the power of sovereigns, I guess, and sovereign immunity. So, yeah. All right. All right. All right, we're going to try something different, which may or may not work, guys. So this case is 130 pages long, and I'm not going to read all 130 pages because obvious. I tried to use a tool to automatically summarize this for me. So we're going to try this and see how it works. So everything I'm going to read is from the case. It's an automatic computer generated summary, though, so we're going to give it a shot and see how it goes. So if it goes horribly, we'll pretend the whole thing never happened, okay? Our next case deals with student for fair admissions versus Harvard. So there have been allegations that Harvard College has been illegally discriminating against people on the basis of race. In particular, that they have been elevating certain races and they've been causing other races to have lower admission probability, particularly in this case, Asian students who have been alleging that they have been discriminated against. So this case is challenging those policies. The district court has issued a 130-page decision that goes into why this is a valid policy for Harvard. So we're going to read excerpts from this case and try to determine why the Harvard decision is the way it is. So let's get started. On February the 18th, 2015, Harvard filed its answer in which it denied liability. On April 29th, 2015, several prospective and then current Harvard students filed a motion to intervene. This opinion uses the term Hispanic, African American, Asian American, and white to describe the four racial or ethnic identities that account for the majority of applicants to Harvard because those are the terms the parties have been using in litigating the case. The terms Asian American as opposed to Asian is used because it's alleged that Harvard discriminates against United States citizens who identify as Asian American. On September the 23rd, 2016, Harvard moved to dismiss the lawsuit for lack of standing and judgment on the pleadings as to the counts. Following the conclusion of discovery on June the 15th, 2018, the parties filed cross motions for summary judgment on the remaining 4 counts, to which the court denied this. The case proceeded to trial on the counts, and from October the 15th through November the 2nd, 2018, the court heard testimony from 18 current and former Harvard employees, 4 expert witnesses, and 8 current or former Harvard College students who testified as amici curiae, people who were interested in the case. On February the 13th, 2019, following the party's submission of proposed findings of fact and conclusions of law and responding to each other's submissions, the court heard final closing arguments. The court now makes its following findings of fact and conclusions of law. So this has been 7 months after the trial ended for the court to write its decision, which makes complete sense because it was 130 pages. So it took a lot of time because the trial court knows with 100% certainty this is going to the United States Supreme Court someday. So they want to make the record as full as possible. So good for them. On October 13th, 2018, the court heard testimony from Dr. Ruth Simmons, the current president of Prairie View A&M University. President Simmons was born sharecropper shack on a plantation in Grapeland, Texas. She attended primary and secondary school in a completely segregated environment in Houston, and then Dillard University, an African American institution supported by the Methodist Church in New Orleans. President Simmons was selected to suspend her junior college years at Wesley, where she studied alongside white students in the United States for the first time. After graduating from Dillard University, President Simmons traveled to France, where she studied as a Fulbright scholar. She then returned to the United States and earned a PhD. President Simmons held positions at Princeton University, Spelman College, and Smith College before becoming president of Brown University. President Simmons offers expert testimony on Harvard's interest in diversity. Her testimony and her life story, perhaps the most cogent and compelling testimony presented at trial, demonstrates the extraordinary benefits that diversity in the education classroom can provide for students and students and institutions alike. Evidence at trial was clear that a heterogeneous student body promotes a more robust academic environment with a greater depth and breadth of learning, encourages learning outside the classroom, and creates a richer sense of community. In the aid of realizing its mission, Harvard values and pursues many kinds of diversity within its classes, including different academic interests, belief systems, political views, geographic origins, family circumstances, and racial identities. The interest in diversity and wide-ranging benefits of diversity were echoed by all of Harvard's admissions officers, faculty, students, and alumni that testified at the trial. The plaintiffs do not contest the importance of diversity in education, but they argue that Harvard's emphasis on racial diversity is too narrow, and the full benefits of diversity can be better achieved by placing more emphasis on economic diversity. As examples, students' living assignments, the applicable extracurricular activities, and Harvard's athletic programs refers to an exhibit all produced by Harvard, and all are intended to promote a sense of comedy and encourage exposure to diverse individuals and viewpoints. Harvard established a committee to study the importance of student body diversity, which was chaired by Dean Rashish Karam. The committee reached the credible and well-reasoned conclusion that benefits of diversity at Harvard are real and profound. The committee emphatically embraced and reinforced the Harvard's long-held view that student body diversity, including racial diversity, is essential to its pedagogical objectives and institutional mission. They referred to an exhibit offered by the plaintiffs. The dean of Harvard College attended SNYU, Birmingham, and Colonial College for his undergraduate studies. Deciding which applicants to admit is challenging given the overall talent and size of the applicant pool. Clearly, given its size and strength of the pool, Harvard cannot admit every applicant with exceptional academic credentials. Because academic excellence is necessary but not alone sufficient for admission, the admissions office seeks to attract applicants who are exceptional across multiple dimensions who demonstrate a truly unusual potential for scholarship through more than just standardized test scores or high school grades. To achieve an exceptionally strong and diverse applicant pool, Harvard engages in extensive and multifaceted outreach efforts. Each year, roughly 100,000 students make it onto Harvard's list through data including test scores, then colleges' scores from the ACT, and the College Board, which administers the SAT. Harvard admitted 5.8% of its applicants in 2017 and 5.7% of its applicants in 2018. High school students who make up the search list receive a letter that encourages them to consider Harvard and may also receive follow-up communications. Since the 1970s, Harvard has recruited minority students, including Asian Americans, through its undergraduate minority recruitment program. The program writes letters, calls, and sends current Harvard undergraduates to hometowns to speak with prospective applicants. Harvard's financial aid program guarantees full funding of a Harvard education to students earning less than $65,000 a year and also caps contributions at 10% of income for families making up to $150,000 a year. Harvard, through its recruiting program, employs students who return to their hometowns and visits high schools to talk about the affordability of Harvard and other colleges with a need blinds admissions program. Okay. Several Harvard admissions officers testified generally about reviewing application files as well as about the review of specific files. They each spend time-consuming whole-person reviews where each person is evaluated as a unique individual. They refer to demonstrative evidence presented by Harvard. Understanding the applicant's potential can be achieved while Understanding of an applicant's potential then can be achieved by relying solely on objective criteria. All applications are reviewed the same way, regardless of whether a student has applied for early action or regular decision. The admission office may accept, reject, or waitlist applicants, or in the case of early actions, defer them into regular decision. Students apply to Harvard by submitting a common application or a universal application. If applicants wish to disclose their racial identities, Harvard may take that race into account, regardless of whether applicants write about the aspect of their backgrounds or otherwise indicate is an important component of who they are. Harvard selects alumni to interview candidates based predominantly on geographic considerations. Alumni interviews are provided with an interview handbook that describes the admissions process. Harvard could elect not to receive information about race for all applicants or some subgroups, although it does continue to receive some information about applicants' religion and beliefs from applicants who choose to write about their religious identities in their essays or personal statements. Ratings generally fall within 1 to 4, with 1 being the strongest. The ratings criteria used by alumni roughly correspond to the criteria used by the admissions officers. Beyond providing numerical ratings, alumni interviewers write comments explaining their ratings on the interview evaluation form, which is then placed in the applicant file. In addition to alumni interviews, which are offered to most applicants, a small percentage of applicants interview with the admissions office staff member. Students who have staff interviews tend to be among the strongest applicants, are admitted at a high rate. Asian American applicants are less likely to have a staff interview than white, African American, or Hispanic applicants. Less than 3% of all applicants, but more than 20% of recruited athletes, legacies, applicants on the dean's or director's interest list, and child of faculty staff receive a staff interview. Approximately 52% of applicants and 79% of the ALDC applicants who receive a staff interview are admitted. That's pretty high. Americans are admitted. Athletes, legacies, and on deans or directors' interest lists, or children of faculty and staff, all of whom are advantaged in the applicant's process. So legacy admissions. They later served as director of admissions and worked in the Harvard Fund before becoming dean of admissions. There's significant turnover in admissions, which frequently requires, however, relatively young admissions officers who leave to pursue other opportunities. New admissions officers go through an orientation process that includes training on evaluating applicants and considering race. The training utilizes a casebook that contains lightly edited application files from past years, and new admissions officers are guided on how to evaluate score applications based on files. The applications office holds an annual retreat that sometimes includes professional training development on evaluating applicants, and admissions officers receive annual training from Harvard's General Counsel that covers the permissible use of race in the admissions process. Applications are divided into geographic dockets based on high school locations. Docket subcommittees generally include a senior admissions officer who serves as a docket chair and 3 to 6 additional admissions officers. Each subcommittee officer is responsible for reading all applications from a subset of the docket. Because the same reader and subcommittee review all applicants from the same high school, admissions officers develop a familiarity with respective high school grading practices, academic rigor, and recommendation styles, all of which help them to be fair and consistent across applicants, both from particular high schools and across high schools within the docket. The ratings generally rate from 1 to 4, with 1 being the strongest. Each of the profile ratings are assigned by a first reader, and any subsequent readers are permanently used as a starting point for any later consideration of the applicant document or the full admissions committee. The academic rating reflects an applicant's academic strength and potential based on grades, standardized scores, letter of recommendation, academic prizes, any submitted academic work, and the strength of the high school. The extracurricular rating is assessment of the applicant's involvement in activities during high school and his or her potential to contribute to extracurricular life at Harvard. The potential rating reflects the admissions officer's assessment of what kind of contribution the applicant would like to make to Harvard based on personal qualities. The overall rating reflects the admissions officer's impressions of the strength of the applicant, taking account of all information available at the time the rating is assigned. Admissions officers are permitted to take an applicant's rate into account when assigning the overall rating. Harvard may give the summaries here reflect the class 2018 rating procedures. Although the ratings guidelines are routinely revised, the guidelines and reading procedures for the class of 2014 through 2019 do not differ in material respects. Applicants gain a tip. Applicants gain a standing for distinguished excellences such as capacity for leadership, creative ability, and geographic, economic, and racial or other factors. The admissions committee gives some applicants large tips for non-academic reasons when applicant talent or background suggests admitting them would be especially beneficial. Harvard's objective in giving tips to applicants based on criteria other than individual merit, such as to legacies and children of faculty and staff, is to promote the institution and is unrelated to race. Oh, man. All right, guys, I need to take a very short break. I'll be right back. All right, I'm back. Let's see, where are we? Where am I on this thing, on this PDF? 414. Man. All right, here's what I'm gonna do. I'm gonna cut the stream here. I'm going to probably dump this story because I don't think the way I'm reading this makes sense. I'm going to see if I can find a well written article to cover about it instead, or I'm going to have to go through and manually highlight all this stuff one at a time because I think it's just not flowing the way I want to flow. And I have not been feeling well since lunch, so my stomach is turning knots. So I have a lot more stories to cover, but I'm just not feeling particularly well. So I'm going to cut the stream off here. I might try to pop on later today, though, and try to do a stream this evening. And I'll probably try to do one tomorrow night, depending on stuff. But I just need to take a break for myself, guys. I'm sorry. But I hope, yeah, thanks for the ginger tea idea. I might do that. I hope all's well. I hope you've enjoyed the stream so far. I'm going to scrap this story. And so we at least have two. We have the Nixon story, and we have the drone bombing program story. And I'm gonna try to do the remainder because I got a lot of stuff on my docket that left to discuss. But we'll do later. All right, guys, later for now. Peace. Bye.